Very much. Once again, we will go in the same order. I will call on Commissioner Coleman.
Thank you, Chairman. I want to thank each of you for providing what I considered a very sobering testimony and very compelling testimony. Certainly some legal issues that we will need to explore a bit further. I do have a number of questions, but in the interest of fairness today, I'm going to defer my time, and if there is balance at the end of my colleagues' questions to you, I'd be happy to take them at that point. Chairman?
Commissioner Sweet.
I too, Madam Chair, will pass up the opportunity at this point and yield up my time to the other three.
Commissioner Kennard.
Thank you, Madam Chairman, and thank you, panelists, for your passion for your clients. There's a couple issues a couple things I heard that it really confused me. There seems to be an undercurrent that the utilities are the ones that possess the competence and the character to handle the important matter of termination. We all agree is important, but why is it limited to this group of 8 corporate entities in Pennsylvania? Why are companies like NRG, like Direct, that are very large national companies that do this in Texas, precluded from doing so? You can paint the EGS group with some of the bad actors, for example, that occurred during the polar vortex, but couldn't we design a system so that only companies of character and substance were allowed to put their hand on that lever, all-important lever of disconnection?
Let me take that. I think there are a couple of aspects to that question. The first is because they are regulated public utility commissions, fully under the commission's authority. I think the extent of the commission's authority against licensed entities is much different, and that's what we have been hearing and been told, and what the courts have told us at times, as opposed to the extent that the commission has over regulated public utilities. I think the second thing is, again, these are public utilities that have been in Pennsylvania for hundreds of years, but they're also their facilities. They are the facilities of the utility, so only the utility can actually touch those facilities. I'll put it that way. They're the only ones that can go out and physically terminate or push that button to turn off the meter now that we have automated meter reading. So there will always have to be some type of natural role for the public utility. So what we're doing, though, is we're sort of introducing some inefficiencies into that role. And those inefficiencies are simply going to raise the dollars. And I think the last thing is, again, we don't know what the competency is or will be of out-of-state entities. And the question is, what risk do we want to take in that regard?
And if I may, Commissioner Kennard, I think you raise a good point, and that is there are certainly EGSs
Sorry, Mr.
that have...
Cicero, if you'll introduce yourself for the record again.
Thank you. I will do so. Patrick Cicero.
We all know who Patrick.
On behalf of Cause PA. There are certainly EGSs that are technically proficient, right? So this is not about transactional efficiency, right? This is not about could we envision a world where this is technically possible, although I do suggest that the 10 kind of policy technical questions that we talked about 20 years ago should probably be looked at again. But the issue is, as Tanya mentioned, why would we want to introduce more actors into this world where already there are problems that exist, right? I mean, VCS has thousands and thousands of complaints about bills and about terminations, and the EDCs and the NGDCs get these things right most of the time. But sometimes they don't. And when they don't, the commission is there to look over that. INE is there to enforce it. And there is a process that is in place. And so this is not about the technical wherewithal to handle the complicated nature of utility termination, but it's about entities that are well-versed in what the rules around that are. Take, for example, the fact that Chapter 14, which we've talked about, doesn't apply to victims of domestic violence. So if you have a caller who is a victim of domestic violence, who calls in to an EGS, the whole set of rules that they've been trained on don't apply. There's a whole other set of rules that they have to know and understand prior to conducting termination, prior to whether or not they have to offer a payment arrangement, what the notice requirements are year-round as opposed to simply during winter months. And so I think it's about what ought to be as opposed to about what could be. And I think that's what we have to think about in the context of a decision about whether or not to introduce another set of actors into this process, that it's not just about loss of cell service or cable. It's about loss of essential commodity service that really means the difference between life and death for many people.
Of course, in the cell service arena, all manner of products have sprung up to serve low income, prepaid phones. You pay the money up front, you get a certain amount of service. Also, the company from, what's the name of the one that specializes in low income services. So they were sprung up within that unregulated competitive market. Admittedly, a commodity that's not as essential as electricity, but if you allow competition, competition finds a way to serve those markets. But the last question I have is on the issue of these are not utilities. EGSs are not utilities. Agreed, they're not utilities. But you heard Councilor Mowry say that 14 addresses utilities because utilities are the ones that normally undertake these functions. But the commission, could not the commission make as a precondition of allowing this to happen that you will abide by those rules in Chapter 14 as if you were utilities. And if you don't, we will remove your ability to do supplier consolidated billing. We will fine you and do everything else that we do to the existing classic utilities, the distribution and transmission companies. So while they don't apply on the face of the law, some of the things that you've argued could be made and brought to bear by simply inserting utility for EGS as a precondition to allowing them into the market. Is that
Yeah.
possible?
Well, I thought, that's what we thought before the Delmarva case. We made payment of the assessments by the EGS as a condition of their license. And when EGSs decided not to pay that assessment and to challenge that, the court said, you can't do that. So I think that's the problem that we have in the law today.
Yeah, and I think to that point, DCIDA is somewhat similar. I mean, this commission said, well, we can delegate the authority to EGSs, or EDCs can delegate the authority to EGSs for purposes of offering a time of use rate because they're the default service provider. And although the statute says default service provider, delegation is permissible, and the court said no, it's not. That the legislature knows what it means when it says the word public utility. Or default service provider versus competitive electric supplier or natural gas supplier.
Thank you for those answers.
Vice Chairman Place.
Thank you very much. Again, as I noted in the previous panel, time is far too short. I'm thinking about the 6 minutes I had to ask questions in the previous. Essentially dropped off all my questions about low-income issues because it's just too big a volume to even get down that track. That said, we have part 2 coming up in July, so with luck we have a second bite of the apple. I would take the comments with the gravity that they are due. I thought it was a very compelling case, as you laid out. A couple of issues, perhaps. The PFA question, if we are able, and I want to set aside the legal question, DCIDA and Delmarva. In a way, this conversation is moot if we don't set that aside. But if we work from the assumption that we are able to transfer all the obligations of a utility in Chapter 14, et cetera, onto the EGSs, just for argument's sake, yeah, PFA to me is quite straightforward. I get it, but that the customer service person looks at their screen and they're obligated to ask the question: are you under a PFA? If so, this is how we deal with it. You go down the tree. I don't see that is an obligation that an EGS would be any more likely to disregard than a utility. And please jump in if you want, or wait for me to finish. But the I do worry about all the obligations, particularly how you deal with low-income customers. Is it possible to conceive of a system in which, when you do see a low-income person, whether it's an existing customer, say you're an EGS, and you have an existing customer that has changed circumstances, now they fall under low income, couldn't we write a regulation that says, yes, this person's changed circumstance, boom, you've got to put them back, you've got instant transmission back to the default service at no cost. I think it was Elizabeth or Jolene perhaps noted that you could have early termination fees. We could clearly write a statute that says, in the case of changed circumstances, that return to the default service provider, you cannot do an early termination fee. So I think there's ways that some of these can be dealt with, but there's others that I want to hear that you say, absolutely, there's just no way you could write a statute that could accommodate that. For example, LIERP is one of my concerns. Can we write statutes that would ensure that there's that seamlessness that the utility securely has to work through the menu of options for low-income customers? Say, yes, you're eligible for LIERP. This is how you're eligible for CAP. This is how you do it. Are all of those strictly unable to conceive of a statute that could pass that obligation on to VGS? So I've been long-winded, but feel free.
In addressing the PFA question, I can do that, and perhaps in that context address the rest of the question. I think one of our biggest concerns is the sheer volume that's likely to occur. It's quite difficult to assist consumers in addressing complaints that happen with the 7 EDCs and I think 7 or 8 natural gas suppliers. And we do so. Pulp has a utility hotline, and we've handled 500 utility cases for low-income consumers in the last year since July 1st. We're able to resolve most of those by a negotiated settlement with a utility directly. If we're dealing with dozens more companies, the complexity of that, we wouldn't shy away from it, but the ability to serve will be constrained. And I think you can look back to the comments of the Pennsylvania Coalition Against Domestic Violence in the retail market investigation, where they raised many of the very same concerns. At that time, it's been a long road to get the domestic violence protections implemented appropriately with the 7 EDCs. If you expand the universe to include just the suppliers at this table, you have dozens more to train, to provide technical assistance to, and to help survivors navigate the system. I still get calls every day, and I'm not exaggerating when I say every day, from victims of domestic violence who have been denied the protections. They've mentioned it to a call center who just doesn't know. And this is with companies who have been regulated for decades. This has been a protection in the law for well over a decade and was reauthorized and expanded in 2014. And we're still facing an implementation battle. So again, we're not saying that other companies may not have the capability, but they do not have the know-how and the amount of resources that we would need to commit in order to duplicate a system that's already functioning. I didn't hear anything today about products and services that aren't currently available in the market, that aren't currently capable of being implemented under the current system. So if you're going to duplicate that and make this universe much wider as far as enforcement, we have serious concerns about our ability as social service providers to serve the needs of low-income, vulnerable folks, especially victims of domestic violence and medically vulnerable customers.
That's fair. Anyone else want to comment on that?
The only other, I think Elizabeth summed it up pretty well. The only other thing I want to add to this is that there are smart people in this room and outside of this room who could probably craft really well-documented contracts, rules, and regulations that cover contingencies. And so the issue, again, is not whether or not you can create words on a page that will try to bind entities contractually or otherwise. But promises are malleable and facts are stubborn, right? And the facts suggest that even in this context of regulated EDCs, sometimes things go wrong. And the promises of future compliance, the promises of contractual compliance, the promises of voluntary compliance, when it's not clear to me what the problem actually is that we're trying to solve, that already can't be dealt with in a utility consolidated billing or dual billing scenario, just doesn't satisfy us, to be quite honest. And that's the concern. Not that there couldn't be contractual provisions written or regulations or statutes changed, perhaps, but it's why would we want to go down this road? And unless there's a really good reason why, I'm not sure it's worth the time and efforts of Pennsylvanians to get to that place.
And to that point, yeah, I see the effectiveness of dual billing to answer a lot of the questions of the disproportionality or the lack of a level playing field. But to your point, the problem statement here is that do I, as a commissioner, have an obligation to level the playing field here? I mean, I get that there's a disparity between the EGSs and their ability to be visible when utility has control of that end product, the bill and the ability to do inserts and so on. I don't struggle with that that EGSs could handle safety or energy efficiency inserts and so on. I think that's manageable. But and again, maybe this is a bit out of the conversation we're having with the low-income advocates, but and the consumer advocate, but should I be concerned about that level playing field? Do I have an obligation in the Electric Competitive Act to make sure that there's a level playing field?
Only among equals. And I would submit that when we're talking about the Choice Act, and we're talking about billing, and we're talking about consumer protections, we can't ignore the shalls of the legislature. It talks about the shalls being about consumer protection, customer service that includes things like billing. So we're not talking about commodity service. We're not talking about unbundling of the price to compare versus the offerings of EGSs. I think the Commission does have the obligation in that context to make that fair. Is the PTC what the PTC ought to be in comparison to the commodity offering of the generation suppliers? The Choice Act was about lowering generation costs, and that's what we should be focusing on. And so this idea of creating a level playing field for purposes of billing, I don't think I don't think there's anything in the statute that I'm aware of that either requires, compels, or suggests that this is what the PUC should be doing.
And to your point, the dual bill would essentially accomplish that. It levels the playing field and the billing piece on the commodity piece.
Yeah, and I just have to agree with Patrick. I mean, the obligation is to implement the Restructuring Act, and the Restructuring Act allows for the dual bill, but it also, as Patrick points out, it's all about lowering the price of electric generation. And here what we're talking about is trying to use access to the utility bill for other products and services that are not part of the Restructuring Act. So I think we have to move away from the question of, are we trying to level a playing field? What we're trying to do is implement the act.
Yeah. Very helpful. Thank you very much. Appreciate it.
Dan, I have 1 minute.
No, yes, we start
I'll let you know that.
6.
But I'm going over, Dan, just so you know. But I think in this conversation with the answering the questions from Vice Chairman Place, you have answered some of the questions that I was going to ask. I did want to give Elizabeth an opportunity to discuss a little bit more in terms of, and I put a star behind it, the issue of LIHEAP funding and the fact that if there was the supplier consolidated billing, they wouldn't be able to, or they wouldn't have the opportunity to have access to that funding. If you could just explain a little bit more, because I was writing down quickly.
Sure, and in our comments, our written joint comments, it's explained further, but there's a provision in the LIHEAP state plan which defines who a vendor can be, and it explicitly, and I could dig it up here, but it explicitly excludes suppliers electric suppliers in particular. So I know there was testimony in the earlier panel about by a supplier who said that they receive LIHEAP, and that must be because they also offer oil and perhaps are a vendor for oil. But as far as electric goes, competitive electric suppliers are explicitly in the Department of Human Services plan prohibited from receiving a LIHEAP grant.
Now, is that unique to Pennsylvania, or is that something, because I know LIHEAP is a federal program, but is it something that's in the provisions of the federal regulation as well?
No, it's not in the, I mean, LIHEAP, as you well know, is a block grant program, lots of state flexibility. This is not a prohibition in the federal authorizing statute. It's specific to Pennsylvania, and it deals with the fact that suppliers are unable to, under the current legal paradigm, request termination of service. EDCs request termination of service. Suppliers, even in a dual billing scenario, wouldn't be able to have LIHEAP be applied to their portion of the bill, because that can't, in a dual billing scenario, be a basis for termination of service. And so that, because LIHEAP is about preventing home heating loss in the winter months, that's the basis for the obligation that's under the current LIHEAP paradigm. And so again, even if DHS could be convinced to change that rule, you would then have a whole host of new vendors that would have to comply with the LIHEAP rules that are unique to Pennsylvania surrounding the application of cash grants and the application of crisis grants to billing.
Okay, thank you. Thank you.
Chairman Brown, any concluding remarks from you or the commissioners?
Commissioner, we're going to go out of order. Let me just say, I think this has been very helpful and educational to all of us here, me in particular. As you know, you see me writing down a lot of things because I have a lot of different questions. And so I just want to thank everyone for being here. Commissioner Kennard.
Thank you for being here.
Vice Chairman, please.
Yeah, all the panelists here and the earlier panel, I'm grateful for all this conversation and look forward to the continuation, not just in the after comments, but in July's meeting as well. Extraordinarily fruitful. Thank you.
Thank you.
Ditto. Thank you all for coming today. Thank you for the audience that's here with us in person and those that are watching us online today. We appreciate your interest in this topic.
And if there is nothing further, then this hearing is adjourned.